You ever walk past a cleaning supply aisle and just trust that the bottle is telling you the truth? Most people do, and that is exactly the gap that gets folks hurt when warehouses, factories, or even your local hardware store get lazy with labels. Hazardous material injuries are weirdly sneaky because the damage often is not from someone hitting you with a truck, it is from a chemical doing its dirty work quietly. Think burns, breathing problems, chemical splashes, or long-term exposure that shows up months later like an uninvited house guest. Here's the wild part. There are actual rules companies have to follow called OSHA standards, and they are about as exciting to read as a phone book. But they matter a ton. If a barrel of something nasty does not have the right label, the right hazard symbol, or the right warning language, that is not just sloppy, that can be straight up negligence. So when a lawyer looks at a case like this, the first question is basically detective work. Who labeled this thing? Or who was supposed to and did not? Was it the manufacturer who shipped it out wrong, or was it the employer who repackaged it into a sketchy, unmarked jug because they ran out of the original container? That distinction is huge because it changes who actually gets sued. Manufacturers can get hit with what is called product liability, while employers can get hit with straight-up workplace negligence, and sometimes both end up on the same court date like an awkward group project. You also got to figure out what kind of injury happened, because a chemical burn case looks nothing like a respiratory damage case. Burns usually need photos, medical records, and sometimes expert testimony from a toxicologist, who is basically a scientist that speaks fluent "this chemical will ruin your day." Now here is where people get confused. They think because they signed some safety waiver at work that they cannot sue. That is mostly a myth, because waivers do not protect a company from their own negligence, especially when the negligence is something as basic as failing to label a hazardous substance correctly. Workers' comp also throws people off, because sometimes you get workers' comp for the injury, but you can still pursue a separate injury claim against a third party, like the chemical manufacturer. It is like getting two different vending machines to pay out instead of just one. Evidence is everything in these cases, almost like trying to win a courtroom drama but with way more paperwork and way less dramatic music. Lawyers want the actual container, the safety data sheet, internal emails, training records, anything that shows the company knew the risk and ignored it. A lot of these mislabeling situations come from cost cutting because new labels cost money and somebody somewhere decided that risk was cheaper than printing. That sounds like a cartoon villain move, but it happens way more than people realize, especially with smaller manufacturers trying to save a few cents per unit. You also have to think about causation, meaning the lawyer has to prove the bad label actually caused your injury, not just that the label was bad. If you got hurt because you ignored a perfectly clear warning sign, that is a different story than getting hurt because the warning sign basically said nothing useful. Doubt creeps in a lot here too because victims often think their case is too small or too confusing to pursue, like they need a law degree just to ask a question. But most injury lawyers offer free consultations, so you are not risking money just to find out if you have a real claim. Preparation matters more than people expect, so if you ever get hurt from something that was not labeled right, take photos immediately, keep the container if you can, and write down everything while your memory is fresh. Your brain is not a filing cabinet, it forgets details fast, especially after a stressful injury. At the end of the day, these cases are about accountability, making sure companies cannot just shrug and say, "oops," when they skip basic safety steps that protect real human beings. It is part science, part law, and part just refusing to let negligence slide because nobody bothered to read the fine print. So if any of this hits close to home or just made you curious about how these cases actually work, do you want to learn more about our company? Check out our links in the description.